The broadcast is now starting. All attendees are in listen-only mode.
Hello, and welcome to today's webinar, Employment Law Update, presented by our sponsor, Heffernan. We're so happy you can join us. My name is Deb Beto, and I will be your moderator today and be monitoring questions you may have during the session. Before we open up the session, let's review a couple of key housekeeping items. First of all of the webinar materials we discuss can be found at the URL currently showing on your screen. I will be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. If you have audio difficulties or a telephone line goes dead during the call, hang up and call back again to the same number. If all lines go dead, watch the on-screen chat box for an alternative call-in number. Please feel free to ask questions or provide feedback by using the chat box or questions box during the webinar. If you are using a tablet, you may need to tap on the screen for the options bar to appear, and then you can select the appropriate option. We may not respond immediately, but we will be working your questions or feedback into the end of the presentation. If we can't get to your comment or question during the session, we'll try to stay on afterwards as long as we can to respond, or we may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout, and the presenter will be answering questions at the end. And lastly, we have a number of webinars upcoming covering a variety of topics, including those listed at the Heffernan webinar website. In addition, we offer the mandatory Preventing Harassment training in English 3 times a year. With that, let's begin today's webinar, Employment Law Update. Our presenter today is Miranda Watkins. Miranda Watkins is an associate in Fisher & Phillips LLP San Diego office. Her practice includes counseling and defending employers in all areas of labor and employment law. Before joining Fisher Phillips, Miranda worked as an associate attorney for a national law firm focusing on employment and general civil litigation matters. Welcome, Miranda.
Thank you, and thanks everyone for joining today. I'm hoping this will be a very informative and helpful presentation for you. We do have a lot to cover. Last year was a crazy year all around. So I've packed a ton of information in here. Know upfront that the nature of this type of presentation, a sort of general employment law update, means that it is going to be more of a high-level review. Unfortunately, because of time constraints, we can't go too into depth, but I wanted you to at least have a good lay of the land, so to speak, for what you should have on your radar for 2021. And then I'm always happy to chat further if you need, more specific information on any given topic. So with that said, we will dive right in. So obviously, one of the bigger developments in 2020 was the election that we had. And with President Biden being voted in, I wanted to give you all kind of a quick rundown of the top workplace law developments that we expect to see under President Biden's administration. So we think President Biden will be focusing on this list of topics: workplace safety, and that makes sense, right, because of the pandemic and whatnot, wage and hour law, and the future of work. And what I mean by that is kind of that independent contractor misclassification issue. Those of you who operate in California, I'm specifically referring to AB 5 and the Dynamics case, and kind of that whole fight with Uber and Lyft and whatnot, that gig economy type model. We also expect to see President Biden focus on pay equity issues, labor relations, employee benefits and leaves. We also expect him to focus a lot on employee privacy, data security, and restrictive covenants. So that refers to non-compete. and whether or not that is legal and enforceable or not. It's not in California, for example, but in other states it is. So it will be interesting to see if he addresses that on a federal level. And then lastly, we expect him to address immigration and affirmative action. So just some things to keep your eye out for under President Biden's administration. Obviously, last year, COVID-19 kind of dominated all of our lives in lots of different aspects. So I want to kind of cover a lot of COVID-19 related issues, clear up the status of some of those laws we saw introduced last year that targeted COVID-19, and then keep you updated on what you need to know for 2021 with regard to the laws that are sticking around. So the last time I checked, we were up to close to 1,500 total COVID-related lawsuits filed nationwide. The most common state that they're being filed in is California, which is probably not too shocking to anyone. The most common case type that we're seeing is issues with remote work and leave conflicts. The second type that we're seeing is with regard to whistleblower type issues. So that would mean, an employee who maybe expresses feeling afraid about coming into work because of a fear of contracting COVID-19, and then that employee is somehow disciplined or terminated for not showing up to work. The most common industries that we're seeing being hit with these lawsuits are healthcare, manufacturing and retail, government contractors and hospitality, construction and in-home services. And sadly, the most common company size that we're seeing being targeted by these lawsuits are kind of those more small to mid-sized companies with 1 to 50 employees. So if you fall into that category, it's important that you kind of stay on top of these issues so that you don't find yourself the subject of a lawsuit. I included this slide as a way to kind of show you all our firm has put together this sort of comprehensive and interactive COVID-19 litigation tracker. So you can click on any of the states and it will kind of give you a rundown of the cases that have been filed. So for anybody who's interested in looking more specifically at COVID-19 related litigation, that's available on our firm's website. Here is just kind of highlighting one specific case. This comes to us from Louisiana, and it was a wrongful death lawsuit that was filed by the wife of a deceased employee. And she essentially alleged that the company negligently caused her husband's death by failing to provide a safe workplace, failing to implement and enforce policies and procedures to protect its employees from COVID-19, a failure to train on COVID-19 issues, etc. So know that that's out there, and these are really things that you need to have top of mind this year so that you don't find yourself fighting a wrongful death lawsuit. We also have seen a ton of developments with OSHA because of COVID. So there have been thousands of COVID-19 complaints and whistleblower filings that have overwhelmed OSHA and Cal-OSHA. The bench strength has been devoted largely to COVID-19 issues over the past year. OSHA has successfully raised a ton of penalties in regard to COVID-19 related issues. And we expect that OSHA will more frequently use the willful, repeat, and egregious citations under the Biden administration. So if workplace safety has not been, kind of your top priority in the past, it should definitely be moved up your priority list now. I wanted to also address the Families First Coronavirus Response Act, or FFCRA. For those of you, just in case you're not familiar, the FFCRA was a law that was introduced last year that required certain employers to provide their employees with paid sick leave and expanded FMLA leave for various reasons that were specifically related to COVID-19. The status of this law is that it expired on December 31st of 2020. However, I bring this up because employers can voluntarily continue to provide FFCRA leave to your employees if you wanted to. Now, why would you do this? Why would you ever voluntarily give employees something that you were not legally required to? Well, a few reasons. The need still remains. I actually personally was kind of surprised that the FFCRA was not extended into 2021 because the whole need for leave is still there. The pandemic, has still been surging. Here in California, we've had a lot of bans, a lot of outdoor dining bans that were just recently lifted, a lot of closures still. So the need for that leave still remains, and leave slows the spread because theoretically, if an employee is experiencing symptoms or has been exposed or is caring for somebody who has symptoms, you don't want that person coming to work and then potentially spreading it to the rest of your workforce. Another reason you may want to consider continuing to provide this leave is that the financial loss may not be quite as significant as you think, because the Stimulus 2.0 package provides for continued tax credit for those employers who do continue to provide this leave. The only caveat I will say is that you do need to consider state tax implications because you may not be able to get the same tax credit under your state tax laws that you would be able to under the federal laws. So on the flip side, there's of course some cons or negatives to continuing to provide this leave when you don't have to. As I just sort of mentioned, the tax credits are not guaranteed and you may not be able to get them at all under your state tax laws. The time spent administering this leave balanced against how often employees are using it may not make sense. There's, of course, the potential for discrimination or retaliation claims if employees are requesting this leave and taking this leave and then being subsequently disciplined or terminated. And it can also be really disruptive, to have a lot of your employees continuing to take this leave. So some things to think about, but that's where we stand with regard to the FFCRA. On a sort of related note, we have a lot of expanded state COVID-19 paid sick leave laws. So like I mentioned at the beginning of this presentation, unfortunately, because of the short amount of time that we have available today, I can't go into the specifics on each of these states, but here's a list of states that did have expanded state paid sick leave laws that addressed COVID-19. So you'll need to check with, if you're currently working with an employment law attorney, check with them. If not, find one and check with them to see what the status is with regard to these specific states and whether those laws are still in place, if they've been amended, and make sure you're complying with any obligations under those laws. Okay, so I know I touched generally on OSHA at the beginning of this presentation, but we're going to dive in a little bit deeper. So some OSHA updates I wanted to make sure that you're aware of. For employers required to maintain work-related injury and illness records, it's now time to prepare and post your OSHA Form 300A. That's the summary of work-related injuries and illnesses. There's also some employers that have to electronically submit that no later than March 2nd. And remember, according to OSHA, COVID-19 is a recordable illness. So any covered employers are responsible for recording cases of COVID-19 if the case is a confirmed case as defined by the CDC, if the case is work-related as defined by the statute, and if it involves one or more of the general recording criteria that's set forth in the statute as well. Another thing to take note of President Biden's administration has also announced that it has directed OSHA to consider whether emergency temporary standards concerning the pandemic are necessary. And the sort of deadline that they've given is March 15th. OSHA then released guidance on how to mitigate and prevent the spread of COVID-19 at work. When it did so, OSHA stated that the guidance was prepared for planning purposes, which we think sort of suggests that that's likely the first step towards OSHA implementing an emergency temporary standard that will provide required and mandatory steps for employers to take. So this is one of those updates that you don't have to do right now, but it's probably coming. So it's a good thing to put on your to-do list. And if you've got the time to get ahead of it now, probably a good idea to start working on this now. So OSHA's latest guidance indicates that implementing a COVID-19 prevention program is the most effective way to mitigate the spread of the virus at work, similar to the standards that we're seeing here in California and also in Virginia. So the following elements that I've noted in the next set of slides are what OSHA is currently recommending. So they think you should assign a workplace coordinator who will address COVID-19 issues, identify where and how workers might be exposed at work by conducting a hazard assessment, identify measures that will limit the spread of the virus at work, consider protections for workers at higher risk through more supportive policies and practices, establish a system for communicating effectively with your workers in a language that they'll understand, including some sort of system for employees to self-report, educating and training your workers on your COVID-19 policies and procedures, instructing those workers who are infected or who have been exposed to stay home, minimize the negative impact of quarantine and isolation through telework and flexible paid leave policies, isolating workers who do show symptoms at work, performing enhanced cleaning and disinfection, providing guidance on screening and testing, recording and reporting of any infections and deaths, implementing protections from retaliation, and setting up some sort of anonymous process for employees to voice concerns about the virus-related hazards, considering making the vaccine available at no cost to employees. And we're going to talk in more depth about vaccine-related issues in a little bit, and not relaxing preventative measures for employees who have been vaccinated. So another thing I wanted to note is that we have seen various states start to implement or amend and update safety laws that are directed at COVID-19. So again, here's your list of states that have safety laws that are now specifically directed at COVID-19. So if you operate in one of these states, you'll need to make sure to reach out to your employment attorney or find a good employment attorney that can advise you as to the current laws for these particular states. I practice in California, although my firm practices in, I think, almost every state in the US. So I'm going to go over a few California specific laws that you should be aware of. But if you have questions about any of these other states, I can certainly put you in touch with the right person. So in California, we have a new Cal-OSHA emergency standard that was approved back on November 19th and took effect November 30th. So for those of you who operate in California, hopefully this has already been on your radar, but if not, it's certainly time to put this at the top of your to-do list. It's very prescriptive and detailed, and now Cal-OSHA can actually cite employers for violations of this. It also includes a significant paid off mandate for employees who are excluded from work because of testing positive or being exposed to COVID-19. And that's unusual because we don't usually see Cal OSHA mandating paid wages. You know, usually they're concerned more with the safety aspect of things. So there's a lot of gray area and varying opinions about whether Cal OSHA can even enforce the paid time off mandate. But I think probably nobody wants to be the test case for that. So just make sure you're aware of what your requirements are in terms of that paid time off mandate. So to quickly run through the Cal OSHA emergency standard, it requires a written COVID-19 prevention program, and there are specific elements that OSHA says have to be included, and this document has to be a standalone document or incorporated into your existing IIPP. So this can't be something that you just add to a handbook. It has to be its own document or added to your IIPP that you already have in place. We have a template of this ready to go. So if anybody who operates in California doesn't have one and would like to just get our template, you can reach out to me separately. The new Cal OSHA emergency standard also requires notice of COVID-19 exposures and cases within 1 business day. Many of the notice requirements overlap with AB 685, but there are some differences. And you also have to notify your local public health departments of any outbreaks. It also excludes, go forward, there we go. It also excludes COVID-19 cases and exposure. So there are very specific timelines for requiring exclusion of employees that have COVID-19 or have been exposed. And like I kind of mentioned with that paid time off requirement, you have to continue to maintain their earnings, seniority, benefits, and right to return to their former job. That sort of tracks the emergency paid sick leave that we saw with the FFCRA. Unfortunately, the FFCRA was a one-time emergency paid sick leave. It was up to 80 hours of leave, and that was all you got. Unfortunately, with the new Cal OSHA emergency standard, there is no language limiting it to just a one-time use. So we unfortunately think that potentially means you would have to give this to an employee over and over again if they were exposed multiple times, for example. And there's also specific return to work criteria. So you cannot insist that employees obtain a negative test before returning to work, which does differ from the CDC guidelines. So can be a little tricky and confusing there. With regard to testing, it requires that you offer free testing during working hours when there has been 1 positive case at work, and additional weekly or twice weekly testing requirements for outbreaks, which is defined as 3 cases in 14 days, or major outbreaks, which is defined as 20 cases in 30 days. There's additional specific requirements related to social distancing and face coverings, employer-provided transportation and housing, training, instruction, etc. So if you want more information, you can certainly reach out to me or check our website and a recent legal alert that we put out that has more detailed information on that. So kind of in line and related to the workplace safety issue, we're also seeing states that now have workers' compensation presumptions for COVID-19 cases. So here's the list of states that either already have a law that has been passed that indicates a worker will be presumed to have a workers' comp issue if they test positive for COVID-19 at work. I've tried to note here the states where those laws are just pending. So if you operate in those states, you'll want to keep an eye out for whether those get passed. And then note that in Alaska, that law was enacted, but expired last year, but maybe a good idea to keep an eye out to see if that somehow gets renewed this year. Here in California, we saw the passage of SB 1159. That was the subject of one of Governor Newsom's executive orders during the pandemic. It was certainly one of the hot issues when the legislature returned multiple bills that dealt with this subject. But ultimately, the one that was signed was SB 1159, and it went into effect immediately. So that was tough for a lot of employers who really had no heads up and no way to prepare for this. So the law has three parts. It codifies the executive order that ran through July 5th. That said, a case is presumed to be covered by workers' comp if the infected employee tests positive or is diagnosed within 14 days of their last day worked outside their home. The doctor's diagnosis has to be confirmed by a test within 30 days, and the presumption is rebuttable by evidence, but the claim has to be denied within 30 days to be eligible for rebuttal. The rebuttable evidence, too, is tough. It's really tough to prove that your worker did not contract COVID-19 at work if they worked for you in the 14 days prior to the positive test. The second thing this law does is that it extends all of the above for first responders and healthcare providers so that the executive order provisions bridge beyond July 5th for those groups. It also creates a new rebuttable presumption for cases occurring on or after July 6th, but only where the employer had an outbreak. So for purposes of this, an outbreak is defined as 4 positive tests in 14 days if you have 100 employees or less. If you have over 100 employees, then an outbreak is defined as 4% of your employees with a positive test, or if you are shut down by the public health authorities. Your workers' comp carrier reporting requirement, that was added as well. So when an employee tests positive, you have 3 business days to report that. Plus, there's a look-back reporting period to positive tests that date back to July 6th, within 30 business days of the effective date of the bill. So it's a lot of sort of very convoluted timing procedures, which is why it's important to make sure you have a good employment law attorney on hand who can help you navigate that should you find yourself dealing with an outbreak. So we mentioned AB 685 earlier. This is a California law that targets COVID-19 reporting obligations. This legislation was introduced following some very highly publicized outbreaks where employers were alleged to not have informed the rest of their employees that there had been an outbreak. It imposes some significant and complex notice requirements as well that took effect on January 1st of this year. So we're about a month into this law. Under AB 685, employers are required to provide notice within 1 business day when they receive notice of a potential exposure. That notice can come in a lot of different ways. So I've listed some here. It could be notification from a public health official or medical provider that an employee was exposed to a qualifying individual at work. It can also be notification from the employee themselves or their emergency contact. It can also be notification through your own employer testing protocol, or it can be notification from a subcontracted employer that person was on site. So what is a qualifying individual? We kept using that phrase over and over in that prior slide. It's someone who has had a laboratory confirmed case of COVID-19, has a positive COVID-19 diagnosis from a licensed healthcare provider, has a COVID-19 related order to isolate from a public health official, or has unfortunately passed away from COVID-19. So you must give notice to your employees and any employees of any subcontractors that work for you who were on the premises at the same time as the qualifying individual because theoretically they have been exposed. You also have to give notice to your employees or any subcontractor employees who may have been exposed with information about COVID-19 related benefits that they might be entitled to. You have to also notify all employees of the disinfection and safety plan that you plan to implement, and that should follow the CDC guidelines. If the number of cases meets the definition of an outbreak, and for purposes of AB 685, an outbreak is generally defined as 3 cases, you have to notify the local public health agency within 48 hours and provide them the names of the positive employees, the total number of positive employees, the occupation and the work site of those workers, and the business address and NAICS code of that work site. And then also notify the local public health agency of any subsequent cases. Okay, so now we're going to kind of move forward a bit on COVID-19 and jump into some vaccination issues and guidance that has recently come out. So I'm not going to read this next set of slides to you. I just included this because I thought it was kind of interesting. Our firm recently conducted a survey on employer vaccination attitudes. So really what we were looking at is, are employers looking to make the COVID-19 vaccine mandatory for their employees, voluntary? Are they just going to encourage it? Are they going to be silent on it altogether? Are you going to try and incentivize your employees to get it without requiring that they get it? And if you're going to go that route, how are you going to go about incentivizing them? If you are going to require it or make it voluntary, are you going to pay for it? So things like that, that we kind of wanted to see how employers were thinking about that. So I'll leave these slides for you to look at, in your free time if you're interested in seeing kind of how the responses broke down. But we do have some new EEOC guidance that was issued December 16th on these vaccination issues. So that sort of helps employers to start formulate a plan for how they're going to go about addressing the COVID-19 vaccine. So the EEOC's position is that employers can require workers to get the COVID-19 vaccine under certain circumstances. They did suggest that this same guidance would apply to the emergency use authorization as well. So the only scenario that the EEOC described as when a vaccine can be mandated is when it poses a direct threat. And it noted that you still have to evaluate any medical or religious accommodations that employees may need. So what is a direct threat? If that's the only way that you can mandate your employees get vaccinated, how do we know what a direct threat is? So what the EEOC said is a direct threat is when there's significant risk of substantial harm to the health and safety of others. And the key is that this risk cannot be eliminated or reduced or mitigated by any sort of reasonable accommodation. So an example to kind of help solidify this is if an employee can fully perform their job at home without risking spreading COVID-19 to other workers, you cannot require them to get vaccinated. And that tracks, right? That makes sense, because if an employee is working from home and they're not around anybody else that works for you, there's no concern about them spreading it to another worker. So on the flip side of that, if you have an employee who cannot work from home, let's say they're a manual laborer, for example, and they work in a crew, so they're always around other people, that would be an example of a direct threat where you could legitimately mandate that those workers be vaccinated. Of course, we have to account for potential disability discrimination issues and reasonable accommodation issues. So I'm sure you're already all pretty familiar with the Americans with Disabilities Act, but just to kind of quickly do a refresher on that, that's the federal law that prohibits discrimination. There's also various state laws that track that same prohibition. In California, our law is called PHILLIPS. The ADA also requires that employers reasonably accommodate disabled employees. The ADA also limits an employer's right to inquire or conduct medical examinations and states that in order to force an employee to undergo a medical examination, the examination has to be related to the job that they're performing and consistent with your business need to have that medical examination. The medical condition has to be one that poses a significant risk of substantial harm, and it has to be reliable, objective information that supports your concern. The ADA also has some protections for employee privacy with regard to their private medical information. And then just a quick note there that there's a similar federal law called Title VII that may require accommodation of an employee's sincerely held religious beliefs or practices that would potentially prevent them from getting vaccinated. So in terms of limitations and employer responsibilities with respect to the ADA and the EEOC on this vaccination issue, what we've seen is that per the EEOC, an employee may be entitled to an exemption from a vaccine due to an ADA-covered disability or other medical circumstance. Similarly, an employee could be exempted from a flu shot requirement as well, based on sincerely held religious beliefs, practices, or observances. So in either of those cases, you'll want to engage in and document the communications that you have with your workers to determine whether a reasonable accommodation is needed and feasible, so that you can work out a way for that employee to continue working for you without being vaccinated. And that process, legally, that's called the interactive process, where you have that communication back and forth. That is just as important as your ultimate decision as to whether or not the accommodation is necessary and feasible. At least in California, a failure to kind of go through that interactive process, that's its own separate legal claim that somebody can sue you for. And it's really tough to defend because it's almost like a strict liability kind of standard. It's very technical and procedural. So you either did engage in an interactive process or you did not. And if you did not, the law doesn't care why that didn't happen. So it could be that you didn't realize you needed to, and this was just a simple, honest mistake. Unfortunately, for legal purposes of that claim, it doesn't matter why you didn't engage in that process. So make sure that you're going through that and documenting it so that you can prove you went through that. In terms of EEOC guidance on proof of vaccination, the EEOC has said that employers can request proof of vaccination, that request is in and of itself not likely to elicit any disability type information, that request is not a disability related inquiry. So it should sort of stop that analysis there. Any medical information that you do receive from employees, though, and I would include proof of vaccination in that category, needs to be kept confidential. So it needs to be maintained separate and apart from an employee's personnel file. It should be kept in a separate medical file for that employee, that is not accessible by anyone and everyone. With regard to medical examinations and pre-screening questions, The EEOC has said that giving the COVID-19 is not a medical examination under the ADA. So employers can issue pre-screening questions prior to an employee getting vaccinated, but those have to comply with the ADA's requirements. They have to be job related. They have to be consistent with your business necessity. And again, you need a reasonable belief based on objective evidence that an employee's failure to answer those questions would pose a direct threat. So going back to our example about an employee who maybe has been working in your office, but could work from home, just like you're not going to be able to force them to get vaccinated, you're probably not going to be able to force them to answer pre-screening vaccination questions either, because there is no real need for them to go through that since they're working from home and there's no risk of them infecting anyone else. Circumstances where job-related requirements are unnecessary would include if the vaccination is offered by the employer on a voluntary basis. So if that's the case, then the employee's decision to answer pre-screening questions is also voluntary, and you therefore cannot discriminate or retaliate against an employee if they refuse to answer. Or if the employee receives a required vaccination from a third party that is not contracted by you, like a pharmacy or their own personal doctor, then that would not be, necessary for you to be asking pre-screening questions in that scenario. So a quick summary on what we went through: an employee can be exempt from a mandatory vaccine if they have an ADA-covered disability or other medical circumstance that would prevent them from being vaccinated, or if they have a sincerely held religious belief, practice, or observance that prevents them from being vaccinated. And a quick sort of point of caution with regard to the religious issue: I have a lot of clients that will say, this person saying they have a religious belief that prevents them from being vaccinated, I call BS. I've never heard this person ever talk about being religious. And it's kind of a dangerous road to go down. You can certainly engage in an interactive process with them and talk to them about what their religious beliefs are. Sometimes, you may get a note from a pastor or something like that that describes why the religious tenets prevent that. But without some sort of objective information that leads you to believe this person does not have a sincerely held religious belief, I wouldn't go too far in questioning it. And I would be very, very, very careful about denying or terminating somebody for refusing to get vaccinated because of a religious belief. If you think you want to do that, make sure you talk to your employment attorney first. In either case, remember to engage in that interactive process and document it. You have to make sure you're considering all potential reasonable accommodations. And remember that process is just as important as your final decision is. Some other legal considerations that come up that are sort of interesting with regard to this vaccination issue is you have to take into account state and local laws as well. So state and local laws may protect anti-vaxxers, and there's a couple different theories that would potentially protect anti-vaxxers. Some state laws include political beliefs or engaging in political activity as a protected category that would be prohibited from being discriminated against based on, or counts that as protected activity that you're protected from being retaliated against for. So in other words, if you have an employee who has expressed to you that they're an anti-vaxxer and that could be related to their political beliefs, and then you terminate that employee, they could potentially make a claim for retaliation on that basis. There's also some states that have laws that protect employees from any adverse actions for lawful off-duty activities. California is one of those states. So if an employee is, let's say going to a protest or, a rally or something like that, that's related to being anti the COVID-19 vaccination or anti any vaccinations, you cannot discipline or terminate an employee on that basis. That would be a tough discrimination retaliation claim to fight. And then also remember, employees have rights under Section 7 of the National Labor Relations Act to engage in protected concerted activities. Now, a lot of employers will tell me, yeah, but Miranda, I don't have any union employees, so that doesn't apply to me. Unfortunately, Section 7 applies regardless of whether you currently have union employees or not, because the whole idea of protected concerted activity is employees have to be allowed to talk about their grievances or issues with their current workplace and to discuss whether they would want to unionize. So if your employees are talking about, oh, I don't like this vaccination policy that they've implemented, I think this violates our rights, that's going to be protected concerted activity that you cannot discipline or terminate them for. And then for those of you who may have union employees, make sure to check their collective bargaining agreements, because there may be some provisions that would be relevant to your decision as to whether or not to make vaccines mandatory. And if that's not in there yet, that may be something that you'll have to bargain over probably in the very near future. So should an employer require vaccinations? That's kind of the million-dollar question and the most common question that I'm getting as of late. And what I generally tell my clients is that good employee relations is really, really key for a lot of reasons. Clients and customers and the public will take notice. It's also critical to maintaining focus and productivity and community relations. You also do need to consider the possible susceptibility to union organizing efforts. So if you do not currently have unionized workers, but rolling out a mandatory vaccination policy could lead to that. So that's something to consider as well. I think we have to follow the availability of the vaccine. That's certainly something to consider. If you're going to make vaccines mandatory, you need to pay for it. So there's a financial consideration that you're going to have to take into account. It will be very, very important to evaluate the likely response of your employees. So this will really come down to what kind of industry are you in? Are you customer facing? Are you non-customer facing? Do you have a lot of remote workers versus a lot of on-site workers? What's the general culture and vibe of your workplace? What state do you operate in? You also need to think through the logistics. So if you're going to make it mandatory, are you doing that on site? Are you requiring everybody to go to an off-site doctor or pharmacy or some other place to get vaccinated? If you're doing it off-site, I recommend that you pay employee, for the travel and for the time spent getting vaccinated. But if you're going to do it on-site, then you need to consider proper training for those people who are going to be actually giving the vaccine. You need to have proper PPE, and you still need to maintain proper social distancing and whatnot. And then don't underestimate the importance of effective communications with your employees and customers and whatnot. One idea I've been floating to a lot of my clients is, if you're unsure, and if you're unsure about how your employees would respond to this, maybe consider putting together an employee survey to sort of gauge the attitude about this. And that might be really informative and might actually surprise you what the response would be. And there's just a little note about our firm has a whole COVID-19 vaccine resource center that we've put together. So that's on our website. It has some frequently asked questions specifically related to the vaccine. There are some sample policies and procedures that you can just pull for free from the website. There's a database of templates and forms. Some of the more complex templates and forms are ones that we can't make publicly available because we would need to customize it for your business. But you can always contact me and we can talk about that offline. We also have some charts on 50 state issues. So if you're an employer who operates in multiple states, you can quickly look at how are these various states, treating the vaccine, or what state laws do I need to pay attention to. So there's lots of good stuff there if you want to take a look at that. Okay, so we'll finish up with a couple of non-COVID related updates, one being wellness programs. The EEOC recently revealed 2 new proposed rules concerning how employers can encourage employees to participate in employer-sponsored wellness programs without violating the law. Those rules were released on January 7th, so just about a month ago, and are slated to be finalized next month. They generally provide that employers have to offer much smaller incentives than you are previously permitted in order to comply with the ADA and the Genetic Information Non-Discrimination Act. But to throw a wrench into that, President Biden has announced that he plans to freeze all pending regulations for review before they're implemented. So this is something to keep your eye on because this could be something that is finalized next month that you would need to comply with, but it could also be on hold for a bit longer. The new proposed ADA rule clarifies the following items: the types of wellness programs, what it means for a wellness program to be voluntary, what incentives you can offer as part of the voluntary program, and what requirements apply concerning notice and confidentiality of medical information obtained as part of that program. And then the new proposed GINA rule concerns whether employers can offer incentives to employees in exchange for their spouse or another family member who participates in a wellness program, providing any information about their manifestation of disease or disorder and or to achieve health outcomes as part of the program. So that gives you a heads up as to what may be coming next month. We'll have to see if that gets put on hold, but something to keep kind of on your radar. And then last but not least, minimum wage. Federally, minimum wage is currently at $7.25 per hour, but $10.95 per hour for federal contract workers. President Biden recently called for an immediate increase to $15 an hour. So almost, just a little over double by 2025. The Senate approved by a voice vote a measure prohibiting that increase. So that's also on hold for now, but something to keep on your radar to see if President Biden just leaves that issue as is, or if he goes back to the drawing board and tries to propose an alternate federal minimum wage increase. And then don't forget to double check any state increases as well, particularly those of you who operate in multiple states. You need to account for multiple and differing increases. California is currently at $13 per hour for employers with 25 or less employees, and $14 an hour for employers with 26 or more employees. But those of you who are in California, you know that we also have varying city and or county minimum wages that are a lot of times higher than the state minimums. So you'll also need to make sure you are accounting for the higher local ordinances. And if you don't know what those are right now, you can reach out to me and I can help you figure out what those are. So last but not least, because a lot of these updates are things that are proposed or pending or on hold but could pop back up, I really encourage you all, if you don't already have some sort of monitoring or alert type system in place, to make sure that you are getting the most up-to-date information as soon as there is a development, whether that's a new case that's come out, a new law that's been passed, a law that's been amended, new guidance that's come out from a federal agency. And there's lots of places to get these alerts. Our firm has one. It's really easy to sign up on the website. If you can't find that or figure that out for some reason, you can also always email me and I can make sure that you get put on our alert system so that you just automatically get an email with any sort of update. We have a huge team of attorneys that monitors all of these changes, and then we'll write a quick legal alert or blog post highlighting the significant changes or updates, and then highlighting what you need to do next. So with that being said, I will take any questions that you guys have. I know we only have a couple of minutes, so I'll get to as many questions as possible. And if we're not able to get to them all, I'm happy to answer offline as well.
Thank you, Miranda. We do have a few questions that came in during the session, and then we're also getting quite a few that are coming in right now. So we'll get to as many as we can. So first of all, does the rebuttable work, you early on in the session, you talked about rebuttable work. Does the rebuttable work have to be continuous, or can the employee have been part-time or reduced hours?
I think they may be referring to the rebuttable presumption with regard to workers' comp.
Yes.
And that is a good question. I'll need to double check if that differs for a part-time or like a temp employee. So if the person who asked that question wants to shoot an email either to the moderator, however that works.
I'll connect the two of you.
Yeah, so then I can follow up on that.
I'll go ahead and get that done. Neither one of you need to do anything. I'll get that going. So the next question regarding the COVID vaccines, what if the vaccination policy is mandated and the person that gets the shots die?
That's a good question, and that's a huge concern for a lot of people. I think that consideration and analysis is really going to come down to, did you do any pre-screening questions? Was there anything that this employee alerted you to, as to them potentially being affected negatively by the vaccine? If there was no notice and no concern, then I think you're in a much safer position. But that's certainly going to be something that any employer who wants to mandate the vaccine is going to have to grapple with, unfortunately.
Okay. And who is allowed to know if an employee has been vaccinated?
That's a good question as well. So we are recommending that you do not disclose to your other employees who has or has not been vaccinated. I think you kind of have to defer to that being considered private medical information that you are required to protect from an employee privacy perspective, which is why any vaccine-related documents, proof of vaccine, things like that, need to be kept in a separate medical file for that employee that is not easily accessible by anyone and everyone.
Okay, and we are coming up on 11 o'clock. I just want to say we are going to be staying on and answering as many questions as we can. So if you're able to stay on, that's great. If you're not, we have recorded this session and we can make a copy of the recording available. So is there any information on the submission of the EEO1 or EEO2 reporting?
If you shoot me an email, I can reach out to our benefits team and get you some info on that.
Okay, I will connect the inquirer with you on that one. And we have a few questions that are coming in regarding specific situations about your company, and I will be connecting you directly with Miranda so that she can get more specifics about your company in order to answer those questions more appropriately. So if I don't get to your question right now, it's because I'm going to get you two connected together. So are we required to pay EMS dispatchers who choose to stay home after a workplace exposure since they're considered critical infrastructure workers?
Say that again. I think you cut out a little bit, so I
Oh,
wanted to make
I'm
sure
so
I heard the full
sorry.
question.
Are we required to
That's okay.
pay emergency medical services, EMS dispatchers who choose to stay home after a workplace exposure since they're considered critical infrastructure workers? If they choose to stay home, are we required to pay for them? So, and this could apply to any critical infrastructure worker, not just, EMS dispatchers. That's just an example.
Yeah, I think it's a little bit of a loaded question in that it's going to matter where you're located as well. Because again, like going back to California and our Cal OSHA emergency standard, they would very likely be required to be paid under that emergency standard if they were potentially exposed at work. But that may not be true for every other state. So I'm a little hesitant to give you a definitive answer, and I hate to give you the lawyer answer of it depends, but it does sort of depend what states you're in.
Okay. And I can send you information about the Inquirer so that if they want to look into it further with you, they can. So regarding COVID-19, do the recordable cases have to be an outbreak from work or outside of work, or can it be either both or combination? How does that work?
That's a good question. And again, there may be some state laws like Cal OSHA's COVID-19 regulations would weigh in on that too. So I would love to know what state or states that person is operating in, just so that I can be sure to give you a complete answer.
Okay. And are the requirements the same for temporary help or employees that work less than 30 hours a week?
I'm not sure which requirements that
COVID-19, I'm sorry.
But I think I'm still not understanding what specific.
Okay, I'll get her in touch with you then.
Yeah.
So if we have employees who tested positive for COVID but didn't start a workers' comp claim, do you still have to list those on your OSHA 300 form?
That is a great question that I can ask my benefits team. I don't really practice in that area a whole lot, so I know enough to know the general things you need to look out for, but not enough to know the specifics about those forms. But I can certainly get that answer for you.
And I have a little bit of insight on that. You're supposed to report any workplace injury or illness, So it doesn't have to have it doesn't have to have turned into a claim. So we have temporary labor in our plant, and we're in California. Janine, I will get you in touch with Miranda specifically on that one. That was an answer to one of your previous questions on where you didn't know where she was located. Okay. This is a look into the future, so good luck. When COVID goes away, will all the reporting go away as well?
That is a great question. I don't know that any of us know or have too much guidance as to whether that would go away. I think that it's very possible, given that the FFCRA was a COVID-19 specific law that was in place last year, but not extended into this year. But I could also see the flip side, where we've all kind of realized a virus like this can pop up, at any time. So maybe it's a good idea to have those regulations and requirements in place regardless, just in case, God forbid, this ever happens again. I know we all hope that won't happen, But yeah, I think it's just way too soon to tell. And I think it's also too soon to tell when this current pandemic is going to let up.
Yeah.
I know our firm in particular is projecting that we will not be back into the office until probably September.
Okay. So this next question is regarding FMLA and also the California Family Rights Act that just changed last year. Are employers required to pay for FMLA and CRFA? And if so, what is the pay requirement?
So not for, if we're talking traditional FMLA and traditional CFRA, no, you don't have to pay. That's still an unpaid leave.
Right.
The expansion of CFRA was, there was a couple different things, but one of the most notable ones was that it changed the CFRA from being only applicable to those employers who had more than 50 employees to, I think the limit is only 5 employees now.
Yes.
So it expands CFRA to a lot more employers who did not previously have to give that leave, but it doesn't change the fact that it's still an unpaid leave and it's still 12 weeks. It did also expand the definition of family member. So any employees who need to take a CFRA leave to care for a sick family member, that definition has now been expanded. And I'm glad that person's aware of that expansion. I didn't bring that up since that's a California specific law and this was a more federally focused presentation, but certainly something to keep in mind. The only sort of FMLA type thing that you had to pay for was the emergency FMLA under the FFCRA, but that's the one that since it's expired now, you don't have to give that. It's voluntary. But if you're going to voluntarily give it, then yes, you do need to pay, and it's 2/3 of the employee's pay for the time that they're out.
Okay, excellent. And speaking of FFCRA, if an employer has, opted for the FFCRA and the employee uses up all of their sick leave, can they then go on work comp?
Yeah, they could. The only applicable reason that would qualify an employee for the emergency FMLA leave is to care for a child whose school or childcare, daycare, anything like that has been closed because of COVID-19.
Okay.
So those are 2 completely separate issues. So if they exhaust their 12 weeks of emergency FMLA for that reason, and then they were to contract COVID and have symptoms or have to care for a family member who has symptoms, they could potentially go on a workers' comp leave or a reasonable accommodation leave. So there can be an interplay there.
Okay. And a few people are asking about the federal payroll tax credits. Do you have any updates on that?
I did not include those in here because I thought I had already included a lot, but we have a whole team of attorneys that is dedicated to those types of issues. So I can certainly connect you with the right people who could answer your questions on that.
Okay. And back to COVID and the vaccines, the requirement for vaccines. How do you handle that for a pre-hire requirement?
That's a good question. I think the analysis is pretty much the same. So if you're going to mandate it, you have to look at, is that going to be a direct threat? Is that person going to be working on site and with other people? If not, if this potential new hire is going to be working from home, then I don't think you can mandate it.
Got it.
And then to the extent that the applicant reveals a disability or a religious belief that would prevent them from being vaccinated, you have to still go through that interactive process and figure out if you can accommodate that for them.
Okay. Let's see. If two employees test positive but do not work together, but they do, however, regularly go to lunch together, so they might be off work hours. Contact tracing indicates one infected the other. Is this a workplace recordable infection?
I think it would be. I think it's really hard for employers. Like I think I may have mentioned earlier, I think it's tough for employers to say you definitively did not contract this at work if they have been working for you in the 14 days prior to testing positive. The only scenarios that I have come across where you could legitimately not record that and have your defense be this person did not and could not have contracted it at work is if that employee has not worked for you for more than 14 days. So that could be because they took a vacation or they've been out on a leave of absence for more than 14 days. In those scenarios, I think you can safely say there's no way they could have contracted this at work. Excuse me.
Okay. So if someone works from home 100% of the time with no work-related contact but contracts COVID-19, is it still a reportable event?
Probably not. I would want to run through a few more questions to flesh out how we know for sure that person has not come on site.
Mm-hmm.
You know, so we would need to talk through what kind of workplace you are and what kind of mechanisms you have in place for tracking that. Like our firm, for example, we have to use a fob to get in. So there is a recording of, you know, my specific fob with my fob number got swiped at a certain time so they can tell I came into the office.
Mm-hmm.
I think you would need to run through that before you would want to leave that off.
Okay. And that was the end of the questions. I do want to say that a lot of people are asking for the policy templates that you had mentioned. So I'm not sure. It sounded to me like they could get those policy templates if they go to the Fisher-Phillips website and log on. You have all kinds of resources there. And if you want to make those templates available to us, we can put them on our webinar website as well. We will also send out an email after this session letting you know how to access all of the webinar materials on our website. And then if you would like a copy of this recording, I will ask you to email us directly at moderator@aspenrmg.com, and we will make a copy of the recording available to you.
Yeah, and I'll just note, you know, again, the template should be pretty easy to find. I think on our firm's homepage, there's a link to the COVID-19 vaccine resource center. So if you click on that, then there should be a subsection for the templates that we've been able to make public.
Mm-hmm.
I can tell you, like, for example, the written COVID-19 prevention program,
Mm-hmm.
that's a document that is not made public because it has to be customized to your specific business. And depending on what parts of California you operate in, we have to customize it to account for the different city and or county laws.
Good point.
So I don't know that my firm will let me pull all of the public ones and give them to you guys to post on your site. I can ask. They should be, the general ones should be easy to find. If you can't find them, you know, I'm happy to help you if you want to get in contact with me. And then as for the ones,
go ahead.
As for the ones that are not publicly available, I don't know that list, you know, of templates off the top of my head, but if anybody wants to get in touch with me, I can run through what customizable templates we have that we can't make public.
Okay. That's our presentation today, and we really appreciate everybody attending. Thank you so much for attending today's webinar presented by Heffernan. We will send information by email with instructions on how to access a copy of the presentation on our website. And thank you, Miranda Watkins, for your time and expertise today. We hope all of the attendees found today's webinar to be a valuable use of your time And be sure to join us on March 2nd for Maintaining Staff Productivity. Thank you, everyone, and have a great day.